Here's something worth knowing before you walk into any criminal law exam. The word dishonestly appears in more property offences than almost any other single concept, and getting it right can be the difference between conviction and acquittal. Today we're building the full picture of property offences in English criminal law, from the least serious to the most serious. Think of property offences as a ladder. At the bottom, we have offences that don't require any physical confrontation or threat. As we climb, the offences become more serious, either because force is involved or because the circumstances are aggravated. We'll build this ladder from the bottom up, so by the time we reach the top, you'll understand exactly why each rung sits where it does. Let's start at the base of the ladder. Criminal damage. This is governed by Section 1 of the Criminal Damage Act 1971. The core offence is straightforward. A person is guilty if they destroy or damage property belonging to another without lawful excuse, and they either intend to cause that damage or are reckless as to whether damage is caused. Recklessness here follows the Cunningham subjective test. The defendant must have been aware of the risk and taken it unjustifiably. There's also an aggravated form, if the defendant destroys or damages property intending or being reckless as to whether life is endangered. That aggravated version carries life imprisonment. Lawful excuse under S5 includes a genuine belief you had consent or a genuine belief that property was in immediate need of protection. Note, it only needs to be genuine, not reasonable. Criminal damage sits at the base because it involves no dishonesty and no force against a person. Moving up the ladder, we have handling stolen goods under Section 22 of the Theft Act 1968. This offence catches those who deal with the proceeds of theft rather than committing the theft itself. A person handles stolen goods if, otherwise than in the course of stealing, they receive goods or undertake or assist in their retention, removal, disposal, or realization, knowing or believing them to be stolen. The key mental element is knowing or believing. Suspicion alone is not enough, following the case of Hall, 1985. The goods must actually be stolen at the time of handling. Maximum sentence is 14 years, which reflects how significantly handling fuels the market for theft. Now we reach the backbone of the entire ladder. Theft under Section 1 of the Theft Act 1968. A person is guilty of theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. Every word counts here. Appropriation under S3 includes any assumption of the rights of an owner, even if the owner consents, as confirmed in Gomez, 1993, and Lawrence, 1972. Property under S4 covers money, real and personal property, though land is largely excluded. Belonging to another under S5 is broad. Property belongs to anyone with possession or control or a proprietary right or interest. Dishonesty under S2 gives three situations that are not dishonest: belief in legal right, belief in consent, belief the owner cannot be found. Otherwise, the test from Ivy v. Genting Casinos, 2017, now confirmed as the law by the Supreme Court, asks, what were the defendant's actual knowledge and beliefs? And were they dishonest by the standards of ordinary decent people? Gone is the old gosh two-stage test. Finally, intention to permanently deprive under S6 includes treating property as one's own, regardless of the other's rights. Maximum sentence, 7 years. Theft is foundational. Robbery and burglary are both built on top of it. Burglary sits above theft on the ladder because it involves an additional wrong, trespass. Under Section 9 of the Theft Act 1960, there are two distinct forms. Section 9, Sort 1A. A person enters a building or part of a building as a trespasser with intent to steal, inflict grievous bodily harm, or cause criminal damage. The intent must exist at the moment of entry. Section 9, Form 1B. A person who has entered a building or part of a building as a trespasser and then steals, attempts to steal, or inflicts or attempts to inflict grievous bodily harm. Notice, 91B doesn't require intent at entry, only that the ulterior offense is actually committed or attempted. Building has been interpreted broadly to include inhabited vehicles or vessels. Part of a building matters too. In Collins, 1973, the Court of Appeal confirmed that entry must be substantial and effective. Trespass requires knowledge of or recklessness as to trespass. Maximum 14 years for domestic burglary. Aggravated burglary sits just below robbery at the top. Under Section 10 of the Theft Act 1968, a person commits aggravated burglary if they commit burglary while having with them any firearm, imitation firearm, weapon of offense, or explosive. The critical word is at the time. For a 91A offense, the weapon must be present at the time of entry. For a 91B offense, at the time of committing the ulterior offense. This was confirmed in O'Leary, 1986, where the defendant picked up a knife inside the house. Liability attached only to the 91B offense because the knife wasn't present at entry. The aggravating element here is obvious. The presence of a weapon creates a severe risk to any occupant. Maximum, life imprisonment. At the very top of the ladder sits robbery, the most serious property offense in day-to-day criminal practice. Under Section 8 of the Theft Act 1968, a person is guilty of robbery if they steal, and immediately before or at the time of doing so, and in order to do so, they use force on any person or seek to put any person in fear of being then and there subjected to force. 3 things to note. First, there must be a completed theft at the heart of robbery. If the theft fails, robbery cannot be made out, only attempted robbery. Second, the force or threat must be immediately before or during the theft. Force after the theft is complete does not convert theft into robbery. Third, the force can be directed at any person, not necessarily the victim of the theft. Clouden, 1987, confirmed that even wrenching a bag from someone's grasp can constitute force. Maximum, life imprisonment. Robbery's position at the top of the ladder reflects that it combines dishonesty, appropriation, and personal threat all in one. Now let's test your understanding. Amara enters a house as a trespasser, intending to steal a laptop. Inside, she picks up a kitchen knife and threatens the occupant. Which offense best describes Amara's conduct? Option A, theft under Section 1 of the Theft Act 1968. Option B, burglary under Section 91A. Option C, robbery under Section 8. Option D, aggravated burglary under Section 10. The answer is D, aggravated burglary. Amara committed burglary by entering as a trespasser with intent to steal, but she then had a weapon of offense with her at the time of committing the 91B offense. That satisfies Section 10 and takes it to aggravated burglary, carrying life imprisonment. From criminal damage at the base, up through handling, theft, burglary, aggravated burglary, and finally robbery at the top, every rung adds a new aggravating element, a higher sentence, and greater harm. Master the structure of each offense, and you'll always know where on the ladder your facts sit. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.